Good morning, everybody. It's 10 o'clock. This meeting is called to order. Mr. Troman, anyone sign up for public comment?
Morning, Commissioners. Les Truman, General Counsel. We have one person registered this morning. It is on item number 14. So when we get to item 14, we will hear from our registrants.
Okay.
Thanks.
Thank you, Les. Appreciate it. Now turn the meeting over to Commissioner Connett to preside over agenda items 3 through 10. So, Mr. Connett.
Thank you, Chairman. Sorry. Thank you, Chairman, and good morning, Ms. Miller. I understand that we have no cases to consider under agenda item 3. Is that correct?
Good morning, sir. No cases.
Very good. Thank you. We will now consider tax liability cases under agenda item 4. And good morning, Mr. Daniel. I understand that we have no tax cases on dockets 39, 40, 41, and 42, but we do have cases on dockets 38 and 44. Is that correct?
Yes, good morning. That's correct. For the record, Hugh Daniel, Special Program Appeals. There's one tax liability case on docket 38, one case on docket 44, and no cases on dockets 39, 40, 41, and 42. So the case number on docket 38 is TD-25-004-0525. Chairman Esparza.
I agree with the recommendation from the staff. Concrete workers were in employment.
Commissioner Trevino.
I agree with staff's recommendation.
Commissioner Connett.
Agree with staff recommendation.
Thank you. The case number on docket 44 is TD-25-005-0525. Chairman Esparza.
I agree with the recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Commissioner Connett.
Agree with staff recommendation.
Thank you all. That concludes the tax liability cases for these dockets.
Thank you. I understand under agenda item 5 that we have no fair housing cases. Is that correct, Mr. Daniel?
Yes, that's correct, Commissioner.
Good. Thank you. We'll now move on to agenda item 6. We have no child labor cases on docket 44. Is that correct?
Yes, sir. That's
Very
correct.
good. That brings us to agenda item 7 and wage claim cases. We have no cases to consider under dockets 38B, 39B, 40B, 41B, or 42B. Is that correct?
That is correct, sir.
Very good. That brings us to agenda item 8 for consideration of wage claim cases on docket 44. There are no wage claim cases pulled for additional discussion on docket 44. Is that correct?
That's correct. None pulled for additional discussion, but you should have received the wage claim short form dissent list for docket 44.
Thank you. I move that we accept staff recommendations on the remaining wage claim cases on docket 44.
I second the motion except for those cases which I am dissenting as reflected on wage claim short form dissent list for docket 44.
I concur with the chairman's motion except for the cases on which I am dissenting as reflected on wage claim short form dissent list for docket 44.
And the motion passes with the exceptions noted. That brings us to agenda item 9 in the consideration of unemployment insurance cases. There are UI cases pulled for additional discussion on dockets 38B through 42B. Is that correct, Ms. Miller?
Yes, sir. That is correct.
Fantastic. Please proceed with docket 38B.
Case number 3669746, Chairman Esparza.
The commission should rehear this case. The claimant was terminated for working unauthorized overtime. Although the claimant alleged that he was performing work during those hours, the employer specified that the claimant was seen on his phone for an extended period of time not performing work. Since the employer alleged that there was video of the claimant not performing work during the time in question, we should rehear this case to review the employer's additional evidence. Please rehear.
The decision is correct. The claimant provided firsthand testimony that in the final incident, he and other employees worked overtime to complete a large order. The employer acknowledged that the overtime was routinely approved when there was work to be done and provided no firsthand testimony or video evidence to support their allegations that the claimant worked overtime hours but was observed not performing work. Therefore, the employer has failed to meet its burden proving that the claimant engaged in actions that could be considered misconduct connected with the work. Affirm the AT, no misconduct.
The employer's testimony indicates that they may have video footage of the claimant staying overtime but not working. Therefore, the employer should be given another opportunity to submit the video or offer another witness to corroborate it. Therefore, rehear for the employer to submit the video and or additional testimony of the final incident.
Thank you. We will rehear the case.
Case number 3674070, Commissioner Trevino.
The AT decision is correct. The employer made the complainant take an employee survey. When the complainant provided some responses indicating problems with members of management, the employer clocked the claimant out and told her that if she refused to retract her answers, they would accept this as her resignation. The employer then demanded that the claimant provide a written statement to go along with her survey. The claimant did not want to provide further statements regarding her survey responses because she felt her problems would not be resolved. So she just told the employer that there were no issues and that everything had been resolved. The employer then fired the claimant. The employer's demand that the claimant retract or amend her survey answers was an unreasonable request, and it was proper for the AT to find that the claimant was discharged for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, charge back.
We should reverse the AT decision. The claimant was discharged for violating the employer's policies. Such violations included using foul language, refusing to comply with reasonable employer requests, and the claimant's confrontational behavior. Thus, due to the preponderance of the credible evidence establishing violations of the employer's policies, the claimant mismanaged her position of employment. Accordingly, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
So in this context, the claimant's choice to respond to her supervisor's questions with profanity constituted work-connected misconduct. Therefore, modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3689318, Chairman Sparsa.
We should modify the AT decision. First, I agree the claim was valid. Regarding the merits, the claimant was discharged for continued mistakes in his work, failing to meet deadlines, and overall job performance. The claimant alleged that he was working to the best of his ability. However, he admitted he spent hours engaging in personal activities and tasks during working hours on company-owned property. By spending so much time and resources on personal activities rather than focusing on his work, the claimant's performance suffered. Thus, because the claimant has not shown he was working to the best of his ability, he mismanaged his position of employment. Accordingly, we should modify the AT decision, valid claim, misconduct, no chargeback, sever adequate employer response.
The decision should be modified. I agree that the claimant filed a valid claim for benefits. However, regarding the job separation, the employer discharged the claimant because he was unable to meet the employer's performance expectations for the CFO role. The employer hired the claimant knowing that he did not have any prior CFO experience and that he would need additional training to succeed in the position. Despite working to the best of his ability to perform and learn the duties of CFO, the claimant was never able to consistently meet the employer's expectations during his few months on the job. Since the claimant was discharged for his inability to meet the employer's performance standards, his discharge was for reasons other than misconduct connected with the work. Modify the AT, valid claim, no misconduct, chargeback, sever adequate response.
The claimant engaged in misconduct when he failed to meet the employer's performance expectations regarding submitting work timely, an issue that was undoubtedly affected by the claimant dedicating time to non-work-related activities while on the clock. Therefore, modify the AT, valid claim, misconduct, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3697053, Chairman Sparsa.
The AT decision should be modified. The claimant digitally signed the employer's policy, which notified her that she needed to call the employer's office for further assignment after her assignment ended. The employer stated its system indicated that no calls were made. The employer's policy also alerted the claimant that unemployment benefits could be affected for failure to follow the policy. Nonetheless, the claimant provided testimony that she did not contact the employer after the assignment ended. Accordingly, the claimant quit without good cause connected with the work. We should therefore modify the AT decision, voluntary leaving, no chargeback, sever adequate employer response.
The AT decision is not correct. The claimant worked for the employer's client for 18 months. The claimant provided credible firsthand testimony that after learning that her assignment would be ending, she sought clarification with the employer about what to do next on 3 separate occasions, including the day her assignment ended. The employer responded by referring to the claimant to the employer's online job board to look for additional assignments, but further work was not available to the claimant at that time. Therefore, since the claimant effectively reported to the employer for reassignment, but was not offered any further work, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback, sever adequate response.
Since the claimant did not follow the employer's policy for making herself available for further work, she voluntarily quit without good cause. Therefore, modify the AT, voluntary leaving, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3704286, Chairman Sparsa.
We should grant a rehearing in this case. The record was not sufficiently developed for us to render a decision. While we are allowed to make reasonable inferences from the available evidence, here the record lacks critical information regarding the employer's receipt of the notice of maximum potential chargeback. Specifically, the record does not indicate whether the notice was mailed to the employer's correct address, nor does it contain the date the notice was received. This information is essential for us to effectively rule on the timeliness of the employer's response. For this reason, we should rehear this case to further develop the record.
The AT decision is correct. The notice of maximum potential chargeback was mailed to the employer's correct address of record. The employer failed to respond until several days after the appeal deadline. Although the employer's witness alleged that they were locked out of their TWC account, the employer did not deny receiving the notice prior to the appeal deadline. Since the employer failed to rebut the presumption of receipt, and because there is no good cause exceptions to the timeliness rules, the employer's response should be deemed late. Affirm the AT, late response to notice of maximum potential chargeback. The employer's account remains charged.
So we should find that the employer filed a late response to the NMPC because they regained electronic access on the day the response was due and still filed 3 days late. Therefore, affirm the AT, late response to the NMPC, chargeback.
Short form dissent.
Yes, sir.
Case number 3711353.
We should affirm the AT decision. Don't contest the timeliness of the claimant's appeal. Concerning the merits, the AT's analysis of the job separation is fully supportable. The employer's policy stipulated that exceeding the allotted unpaid time off balance would result in termination of employment. Although the claimant was aware and was warned regarding her UPT balance, the claimant continued to accrue additional negative UPT for personal reasons unrelated to work. Since the claimant was aware of the employer's policy, her continued accrual of the negative UPT time constituted a mismanagement of her position of employment amounting to misconduct connected with work. As such, we should affirm the AT decision, timely claimant appeal, misconduct, no chargeback.
The decision should be modified. First, I agree that the claimant's appeal should be deemed timely due to the determination being delivered to the claimant after the appeal deadline. However, regarding the job separation, the evidence established that the claimant was discharged without being afforded proper treatment under the employer's leave policy. Although the claimant was discharged for having a negative leave balance, the employer had improperly deducted time from the claimant's leave balance for days that should have been covered by a previously approved leave of absence. The claimant repeatedly contacted the employer to correct this mistake, but no corrections were made. The claimant then requested another leave of absence on the advice of an employer representative. While this request was still pending, and while there was still uncorrected deductions to the claimant's leave balance, the employer discharged the claimant because she had a negative leave balance. After the discharge, the employer informed the claimant her leave of absence request had been denied. Since the claimant relied on the employer's leave policy and kept in constant contact with the employer about the matter, but the employer failed to follow its own policy or warned the claimant that any further absences would be unapproved, the claimant was discharged for reasons other than misconduct connected with the work. Modify the AT, timely claimant appeal, no misconduct, chargeback.
We should hold the claimant not disqualified because under the employer's own policy, all of her absences during the time in question were excused. Therefore, modify the AT, timely appeal, no misconduct, chargeback.
Short form dissent, does that do anything to the timely appeal? Or is there an agreement on
We
it?
have a majority on timely appeal.
Okay, short form dissent on the no misconduct and no charge, or,
Yes, sir.
Yeah.
Yeah, I should say we have a unanimous decision on timeliness of
Okay.
appeal. And we'll limit your short form dissent to the separation.
very good, thank you.
And just to clarify, because it wasn't stated, Chairman Esparza pulled that case. Please proceed.
Yeah, thank you.
Case number 3739951, Commissioner Trevino.
The AT decision is not supportable. The claimant was discharged for violating the employer's attendance policy after receiving several write-ups for missing work due to her own personal illnesses. Though the final incident was caused by an unforeseeable transportation issue, the claimant provided proper notice to the employer of the final incident and testified that all of her prior attendance infractions had been due to illnesses. Since the claimant would not have been fired for the final incident if not for the prior absences caused by illnesses, the claimant's separation was caused by a medically verifiable illness. Modify the AT, no misconduct, chargeback, MVI. However, if my fellow commissioners do not agree that the evidence established that the discharge was caused by the claimant's MBI, I would agree to rehear this case to further question the employer regarding whether the claimant would have been discharged for the final incident if not for her prior absences due to illness.
The AT decision should be modified. The claimant was terminated for violating the employer's attendance absenteeism policy. In addition, the claimant had received a final warning notifying her that another attendance issue could lead to termination of employment. Nonetheless, the claimant was later absent due to a transportation issue, which was a personal reason. As such, the claimant mismanaged her position of employment, and her actions constituted misconduct connected with work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Oh, ma'am. Before you start, Commissioner, I want to just clarify my initial vote of no misconduct, no chargeback, MBI.
Yes, sir.
Okay.
So we have one vote of no misconduct, no chargeback, MVI, and one vote of misconduct, no chargeback, sever adequate response.
This case should be reheard as the record was not well developed. The employer should be given the opportunity to answer further questions. Therefore, rehear for testimony on the claimant's illness, the unsigned August 15th disciplinary infraction, and whether the claimant used her emergency time under the employer's policy.
Ma'am, I'll agree with Commissioner Connett.
Yes, sir. We have a majority to rehear the case.
Case number 3743959, Commissioner Trevino.
The decision is not supportable. The employer discharged the claimant for allegedly violating its code of conduct policy while responding to a child who was acting aggressively towards the claimant. The claimant provided credible, sworn firsthand testimony denying the employer's allegations that he threatened the child and that was merely attempting to de-escalate the situation so that the child would not be injured. Since the employer only provided secondhand hearsay testimony and did not present any direct evidence, the employer has failed to meet its burden of establishing that the claimant's actions were misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
We should affirm the AT decision due to inconsistencies in the claimant's accounts of the final incident and the nature of prior policy violation. His denial of wrongdoing is neither credible nor persuasive. In the contrast, the employer's investigation, which involved numerous witnesses, including staff and non-staff, and a video recording, substantiated the allegations. Therefore, because of the preponderance of the credible evidence established that the claimant violated the employer's zero tolerance policy concerning making threats to children, the claimant mismanaged his position of employment. So, therefore, affirm the AT decision, misconduct, reimbursing employer not billed.
The claimant engaged in misconduct when he admitted under oath to violating the employer's policy. Given the business purpose of the employer, the policy is a reasonable one. Therefore, affirm the AT, misconduct, reimbursing employer, not billed.
Short form dissent, ma'am.
Yes, sir. That was the last case pulled for additional discussion on docket 38B. Moving now to docket 39B.
Case number 3399177, Chairman Sparsa.
We should reverse the AT decision. The claimant was discharged following allegations of sexual harassment. The employer's policy strictly prohibited participation in any conduct that created the potential for harassment, including unwelcome advances, requests for sexual favors, or conduct of a sexual nature. The employer took immediate action upon receiving the complaint and substantiated the allegations after an investigation. The claimant admitted he initiated the inappropriate touching. He also knew that such behavior was prohibited at work. Thus, because the employer met its burden of proving that the claimant violated policy, we should reverse the AT decision, misconduct, no chargeback, adequate employer response, and correct the LEU.
The AT decision on the merits is correct, though the decision should be modified to name the correct employer. Regarding the job separation, the claimant was discharged because the employer alleged that he violated the employer's non-harassment policy and engaged in inappropriate behavior in the workplace with another employee. However, the claimant credibly denied the allegations of harassment, and though he admits to the inappropriate behavior, the other individual involved was not discharged or disciplined because of the incident. The employer failed to provide any firsthand testimony in support of their allegations that the claimant violated the harassment policy, despite being given the opportunity to do so at the rehearing. Therefore, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Modify the AT, no misconduct, chargeback, change ER name, and account number.
The claimant mismanaged his position of employment by engaging in inappropriate behavior in the workplace. As such, he was terminated for misconduct. Therefore, modify the AT, misconduct, no chargeback, correct the LEU, and adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3656979, Chairman Sparsa.
We should modify the AT decision. I agree that the employer had good cause for its non-appearance. Regarding the job separation, the claimant was discharged for failing to perform duties and sleeping on the job. The claimant alleged she performed required tasks and did not sleep on the job. However, the employer provided a video of the claimant sleeping on a binder. Being asleep on the job is a direct violation of company policy. Thus, the claimant mismanaged her position of employment. Accordingly, we should modify the AT decision. The employer had good cause for its non-appearance, misconduct. In the alternative, my fellow commissioners agree we should rehear the case to allow the employer an opportunity to submit a better quality photo of the final incident with a timestamp.
The AT decision is correct. First, I don't dispute that the employer established good cause for missing AT1. Regarding the job separation, the employer discharged the complainant after it was reported that she was sleeping on the job. However, the employer did not provide any firsthand testimony about the final incident, and the claimant denied the allegations under oath. Additionally, while the employer made allegations regarding some prior incidents, the claimant denied the allegations, and the employer did not issue the claimant any written warnings. Therefore, the employer did not meet its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT. Employer had good cause for AT1, no misconduct.
The employer met its burden of proving misconduct when it provided firsthand testimony, written witness statements, and photo evidence that the claimant was sleeping on the job in violation of its policy. Therefore, modify the AT, good cause, misconduct.
Short form dissent, ma'am.
Yes, sir.
Case number 3664251, Chairman Sparsa.
The AT decision should be reversed. The employer witness stated that he was unaware of the claimant being treated with physical violence. As such, the claimant did not provide the employer with an adequate opportunity to address his concerns. While other employees expressed frustration about the claimant's work ethic, this alone did not result in intolerable working conditions. Accordingly, the claimant quit without cause connected with the work. Therefore, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The decision is correct. The claimant resigned due to a toxic and hostile work environment. The claimant reported his concerns to his supervisor, which included an incident where the claimant was threatened with physical harm by a coworker. While the claimant's supervisor attempted to address the issues, the working conditions were intolerable and the situation did not improve, and the employer failed to adequately resolve the claimant's concerns about the working environment despite the claimant's complaints. Therefore, the claimant established that he had good cause connected with the work to quit. Affirm the AT, no voluntary leaving, chargeback.
The claimant quit with work-connected good cause, therefore affirm the AT, no voluntary leaving, chargeback.
Short form dissent.
Yes, sir.
Case number 3664716, Chairman Sparsa.
We should modify the AT decision. I agree that the claim was valid. Concerning job separation, the claimant was separated for failing to meet the employer's job standards. Despite the employer's efforts to provide assistance, the claimant was repeatedly observed using his phone and neglecting his work. Since the employer testified that the claimant's lack of performance was a direct result of his inattentiveness and neglect of job responsibilities, his actions amounted to misconduct. As such, we should modify the AT decision, valid claim, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The claimant was discharged because once his production requirements increased following his initial probation period, the claimant was never able to meet the employer's required performance goals. Since the claimant never demonstrated the ability to consistently meet the increased goals, the claimant was discharged for reasons other than misconduct connected with the work. Affirm the AT, valid claim, no misconduct, chargeback.
In this case, the hearing officer did not gather information on the specific production standards the claimant was able to meet during his probationary period. Without these facts, we don't have adequate information on whether the claimant was previously able to meet the employer's production standards. Therefore, rehear for testimony on the production standards the claimant met during his probationary period.
And we have not yet achieved a majority vote.
I'll agree with Commissioner Connett.
Thank you, sir. We will rehear the case.
Case number 3676395, Chairman Sparsa.
We should reverse the AT decision. Claimant was discharged for combative and belligerent behavior during a disciplinary meeting with her supervisor. The employer provided two firsthand witnesses who testified that the claimant screamed, yelled profanities, and created disturbance on the employer's premises in the presence of customers. Thus, because the preponderance of evidence established that the claimant mismanaged her position of employment, we should reverse the AT decision. Should be misconduct, no chargeback, adequate employer response.
The AT decision is correct. The employer discharged the claimant for allegedly being combative when questioned by her manager about an incident with the vendor. The claimant denied the allegations of misconduct under oath, and the employer only offered vague secondhand evidence about the claimant's actions. At the commission rehear, the employer presented testimony from two cashiers who indicated that the claimant was yelling at the manager, but they were not present in the office during the meeting between the claimant and the manager and only heard what happened after the manager had already discharged the claimant and told her to leave the store. The claimant continued to credibly deny the allegations of misconduct. Therefore, it was properly concluded that the employer did not carry its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The employer has presented sufficient evidence to show that the claimant mismanaged her position of employment by creating a hostile work environment. As such, she was terminated for misconduct. Therefore, modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3700374, Chairman Sparsa.
Commission should rehear this case. The claimant was terminated for providing false information about a supervisor. While the claimant maintained she overheard her supervisor make demeaning remarks, the employer stated that they possessed video evidence purportedly contradicting her account and demonstrating that the supervisor did not engage in the alleged behavior. Due to the potential significant impact of this video on the outcome of the case, a rehearing is necessary to allow for its admission and review by the commission. Rehear.
The decision is correct. The employer discharged the claimant, alleging that she provided false information in a harassment complaint she filed against her supervisor. The claimant provided credible firsthand testimony regarding her supervisor's actions, while the employer provided no direct evidence to support their allegations. Therefore, the employer failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The case should be reheard to review security footage that would definitively answer the question of whether the claimant made a false accusation against her supervisor. Rehear to review that security footage of the final incident.
We will rehear the case.
Case number 3734006, Commissioner Trevino.
One second.
Did we skip one, ma'am? I have 3727669.
As do I.
Same.
I'm sorry,
Yes, sir. We'll go back to 3727669.
Commissioner Sparsa.
Thank you. We should reverse the AT decision. The claimant was on a final warning for unprofessional conduct toward coworkers. Despite repeated warnings regarding his aggressive behavior and demeaning attitude, the claimant continued acting in a disrespectful way, berating and calling another employee stupid. Given the claimant's awareness of the employer's professionalism standards, his continued disrespect treatment of coworkers constituted mismanagement of his position of employment, amounting to misconduct connected with the work. As such, we should reverse the AT decision. Misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant based on complaints from other employees that he was difficult to work with. The complainant provided credible and consistent firsthand testimony denying the employer's allegations that he ever acted in an aggressive manner while interacting with his coworkers. The employer's secondhand hearsay testimony and evidence are insufficient to overcome the claimant's sworn denial. Therefore, the employer failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The employer has indicated that it can formally submit 2 written witness statements into evidence. Therefore, we would like to vote that we rehear for the employer firsthand testimony, prior warnings, and written witness statements to be submitted into the evidence.
I'll agree with Commissioner Khan on rehear.
Thank you, sir. We will rehear the case.
Case number 3734006, Commissioner Trevino.
The decision is correct. The claimant was a home health care worker, and the employer removed the complainant after her last assignment due to her client's inappropriate behavior. After a week, the employer offered the claimant a couple of assignments that she could not accept due to the distance from her home. The claimant reached out to the employer the next week and accepted another assignment. However, the employer then withdrew the assignment because the client no longer needed a provider. The employer did not offer the claimant any new assignments at that time, so the claimant then filed for unemployment benefits. The employer therefore initiated the job separation due to the lack of work by withdrawing the offer assignment without offering any additional assignments, and the claimant was separated for reasons other than misconduct connected with the work. Affirm the AT, no misconduct.
The AT decision should be modified and decided under Section 207045 of the Act. The employer, a home health company, provided testimony that it offered the claimant 2 additional assignments after her prior assignment had ended. The employer further stated that the assignments were at the same rate of pay and with comparable hours as her previous assignment. For the employer, the claimant turned down both assignments and did not contact the employer again. As such, the claimant initiated the job separation and quit without work-connected good cause. We should therefore modify the AT decision, voluntary leaving.
The claimant voluntarily left her position when she declined 2 offers of continuing work. Therefore, modify the AT, voluntary leaving.
Short form dissent, ma'am.
Yes, sir.
Case number 3734928, Commissioner Trevino.
The AT decision is not supportable. The claimant received the initial determination dated December 15th, 2023, and went to her local Workforce Solutions office that same day to file her appeal. The claimant testified that she faxed her appeal, but that she was not given a fax confirmation sheet. Several months later, the claimant contacted the commission to inquire about the status of her appeal and was informed that it had not been received by the commission. Since the complainant faxed her appeal from a commission office, staff should have ensured that the claimant's appeal went through and that the claimant was given a fax confirmation sheet. The staff's failure to do so is commission misinformation sufficient to deem the complainant's appeal timely. Reverse the AT, timely claimant appeal, resubmit.
The AT decision should be modified. Regarding timeliness, the claimant filed her appeal late. The claimant stated that she attempted to submit a timely appeal, but she has no proof of having done so beyond her testimony. In sum, there is insufficient evidence to establish the claimant filed a timely appeal. We should therefore modify the AT decision, untimely claimant appeal, voluntary leaving, void chargeback ruling.
We should not deem the claimant's appeal timely in this case because she did not offer credible testimony that she made a good faith effort to appeal within the appeal period timeframe. Therefore, modify the AT, late appeal, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3740041, Commissioner Trevino.
While the claimant filed her appeal to the AT a few days after the deadline, this case involves a continued claim related to the claimant's working as a marketplace contractor in self-employment. As such, there was no separation from employment and the continued claim should be voided. Timely claimant appeal, set aside AT decision, void the continued claim.
We should affirm the AT decision. Regarding timeliness, the claimant filed a late appeal because she was confused and thought she had submitted an appeal when, in fact, she had not. Furthermore, although she had been checking her TWC inbox, she failed to open the determinations in question, but could not explain why. Thus, the claimant's appeal is not timely, and we do not have jurisdiction to consider the underlying merits. Accordingly, we should affirm the AT decision, late claimant appeal, voluntary leaving, and overpayment.
The available evidence on the voluntary leaving issue suggests that the claimant was sporadically working as a gig worker while looking for other work. Because appeal time limits do not apply to a determination that is found to have been void from inception, we should deem the appeal timely. The case should also be resubmitted to verify the underlying merits. Therefore, modify the AT, timely appeal, resubmit.
We have a majority vote that the appeal is timely, but what to do about the underlying merits doesn't match.
Ma'am, I'll agree with Commissioner Connick.
Thank you. We will resubmit the case. And that was the last case pulled for additional discussion on docket 39B, turning to docket 40B.
Case number 3663890, Commissioner Trevino.
The decision is not supportable. The claimant worked for the named employer for over a year. She was paid an annual salary and the employer reported her wages to the TWC. While the employer is a nonprofit organization that receives donations from both churches and individuals to provide services to the unemployed in Houston, the employer testified that they were not a religious organization and they are not run by a church. While the employer changed their testimony at the rehear, it was clear that both parties had considered the claimant's work to be an employment, as the employer reported the claimant's wages to the commission, and the claimant had no reason to think that she was not entitled to the benefits that she was awarded based on her employment. Therefore, we should find that the claimant was entitled to wage credits reported to the commission. Reverse the AT, claimant awarded wage credits from this employment, no overpayment. In the alternative, if it is determined that the claimant's work was not an employment, we should hold that the overpayment is not credible. The claimant made no representation about her work or her claim, and the overpayment was solely the result of commission error in awarding the claimant wage credits that she was later found not to be entitled to. Modify the AT, no wage credits from employment, overpayment not collectible.
The AT decision should be affirmed. The available evidence indicates that the working relationship between the claimant and the named employer did not constitute one that was, quote unquote, in employment. As such, the claimant is not owed additional wage credits. We should therefore affirm the AT decision, claimant not entitled to additional base period wage credits from the named employer and overpayment.
The weight of the evidence suggests that the employer operates primarily for religious purposes and is principally supported by an association of churches. As such, the employer is exempt under Section 201.066 of the Act, and the claimant's work for the employer was not in employment. Therefore, affirm the AT, no additional wage credits, overpayment.
So the majority vote is no additional wage credits. So request for wage credits denied. Overpayment remains in effect.
I'll short form dissent, ma'am.
Yes, sir.
Case number 3692484, Commissioner Trevino.
The decision is not supportable. The employer discharged the complainant following a disagreement that he had with his manager. The claimant provided credible and consistent firsthand testimony that he was told by his manager to pack his things, take the rest of the day off, and that he would be notified later when he could return to work. The claimant denied the employer's allegations against him and was waiting for confirmation to return to work. Since the claimant was not told to return to work the following day, and because no further work was offered to the complainant, he was separated for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, void chargeback.
The AT decision should be affirmed. The claimant gave the employer a reasonable impression that he was quitting. The employer stated that continuing work was available to the claimant and that he showed up on the property to pack his belongings. It also appears from the information on file that the claimant did not clarify his job status because he felt it would not do any good. As such, the claimant quit without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, void the chargeback ruling.
The claimant voluntarily left his position because, rather than clarify his job status following a supervisor's reprimand, he removed his belongings from his workspace and refused to return to work. Therefore, affirm the AT, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3724387, Commissioner Trevino.
While the complainant filed her appeal to the AT after the deadline, this case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there is no separation from employment, and the continued claim should be voided. Timely claimant appeal, set aside the AT decision, void the continued claim.
We should affirm the AT decision. The claimant delayed filing her appeal, citing two reasons. One, her belief that she would not prevail on her appeal after a conversation with the TWC representative. And two, her focus on securing full-time work. She finally decided to appeal once her severance pay had run out. Because there are no good cause exceptions to the timeliness rules, the claimant's appeal is late, and we do not have jurisdiction to consider the underlying merits. Affirm the AT decision, late claimant appeal, voluntary leaving, overpayment.
The available evidence on the voluntary leaving issue suggests that the claimant was sporadically working as a gig worker while looking for other work. Because appeal time limits do not apply to a determination that is found to have been void from inception, we should deem the appeal timely. The case should also be resubmitted to verify the underlying merits. Therefore, modify the AT, timely appeal, resubmit.
Ma'am, I'll agree with Commissioner Conant.
Thank you. We will resubmit the case.
Case number 3733053, Commissioner Sparsa.
We should affirm the AT decision. The claimant was discharged for using dish soap instead of the prescribed cleaning agent to sterilize surgical dental instruments. The claimant testified she knew using dish soap was prohibited, and she did not seek guidance when she ran out of the approved enzyme solution. As a result of the claimant's actions, the employer had seen patients for 2 weeks without proper sterilization techniques being followed. Such a failure resulted in serious health risks to the employer's patients and exposed the dental practice to potential legal liability. Because the claimant violated the employer's sterilization protocols without the employer's knowledge or consent, she mismanaged her position of employment. Affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. The claimant was discharged for failing to use the proper cleaning agent to sterilize the employer's surgical instruments. The claimant provided credible testimony that she had received no prior training or direction from her employer on the proper use of an enzyme cleaner to sterilize the instruments, had no prior warnings, and that her actions did not cause any damage to the equipment. Since the claimant denied the employer's allegations that she mismanaged her position or neglected her job duties, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The claimant should be disqualified for misconduct because she unnecessarily placed the health and well-being of patients at risk when she negligently chose to use a substitute cleaner without permission or notifying the employer. Therefore, affirm the AT, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 37384887, Chairman Sparsa.
We should reverse the AT decision. The claimant resigned alleging harassment by her supervisor. Upon being notified of the allegation, the employer promptly investigated the claim and took appropriate corrective measures. Although the supervisor subsequently avoided the claimant, she nonetheless resigned, citing general feelings of discomfort. Since the claimant's concerns were addressed in a timely fashion, and moreover, since the claimant resigned when continuing work was available, her separation was voluntary and without good cause connected with the work. As such, we should reverse the AT decision, voluntary leaving, void the chargeback ruling.
The decision is correct. The claimant resigned due to harassment she experienced from her store manager. The claimant informed the general manager of the problem and escalated her concerns about the store manager's repeated behavior to the HR department. While the employer allegedly investigated the matter over the course of a day, the employer took no actions to resolve the claimant's concerns, and she was required to continue working with the same supervisor who had harassed her and other female employees at the store. Therefore, the claimant established good cause connected with the work for quitting. Affirm the AT, no voluntary leaving, void chargeback.
The claimant did not have good cause to quit since her testimony indicates that the harassment ceased after the employer addressed her concerns. Therefore, modify the AT, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir. That was no, I'm sorry. We're going on to the next case. My apologies.
Case
I'm
number
excited too.
3739361, Chairman Sparsa.
The AT decision should be affirmed. Regarding job separation, the claimant was discharged for poor performance. After receiving her second warning, the claimant was on notice that the third warning may result in termination, as evidenced in the employer's records. On the third warning, she rejected an assignment despite the assignment being within her approved radius. As such, the claimant mismanaged her position of employment. Accordingly, we should affirm the AT decision, misconduct, no chargeback.
The AT decision should be reversed. The claimant, a substitute teacher, was discharged for violating the employer's policy about rejecting assignments. The employer's assignment policy was a point system in which the employees earned points by working assignments and lost points for rejecting or canceling assignments. The policy instructed employees that they would be terminated if they ran out of points, but the policy gave no indication that the employees would receive a warning for rejecting an offered assignment if they had available points. The claimant testified that she had points available at the time of her termination, and the employer offered no evidence to the contrary. Therefore, the weight of evidence provided established that the claimant did not violate her employer's policy and was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The employer has not met its burden of proof because it offered no testimony nor submitted its policies into evidence. Meanwhile, the claimant has submitted evidence suggesting the employer did not follow its progressive point system. Therefore, reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3740755, Commissioner Trevino.
The decision is not supportable. Though the claimant was employed by a temporary help firm, her last assignment was a 2-year contract. While she had digitally signed the employer's reassignment policy, This occurred over 2 years prior, and she was not given a copy of the policy. Additionally, the claimant had reached out to her site manager several times in the months leading up to her assignment ending to find out what she needed to do when the assignment ended. The site manager did not remind the complainant of the reporting policy or advise her of any deadlines for calling in her availability. When the claimant called the corporate office the week after her assignment ended, she was told no further work was available at that time. Since this was a long-term assignment, and since the claimant made several attempts to figure out what she needed to do once the assignment ended, but was never reminded or specified or of a specific reporting requirements, and then was not offered any further work when she did call the employer the following week, it should be concluded that the claimant was discharged for a lack of work and did not voluntarily quit. Reverse the AT, no misconduct, chargeback, void adequate response.
We should modify the AT decision. Regarding the job separation, the claimant was discharged by the employer, a temporary help firm, after not following the employer's reporting policy. Instead of contacting the employer immediately after the end of her assignment, the claimant contacted the employer several days later. In addition, the employer's policy also notified the claimant that failure to comply with the policy could affect unemployment benefits. Thus, the claimant is considered to have quit without good cause connected with the work. Accordingly, we should modify the AT decision, voluntary leaving, no chargeback, sever adequate employer response issue.
The claimant should be disqualified because she mismanaged her position when she waited until 8 days after her assignment ended to clarify the reporting policy with the employer as instructed by her job assignment. Therefore, modify the AT, voluntary leaving, no chargeback, sever adequate response.
Short form dissent, ma'am.
Yes, sir.
Case number 3747235, Commissioner Trevino.
The AT decision is not supportable. The claimant, a 10-year employee, had performed her job successfully for many years prior to going on medical leave for her own personal illness in 2022. After returning from medical leave, despite the claimant's best efforts, she was unable to meet the employer's performance standards due to issues with her chronic illness and frequently missing work for medical appointments. The claimant received warnings and attempted to return to her previous performance levels, but was unable to do so. There was no evidence that anything other than the claimant's chronic illnesses caused the decline in her performance, or that the claimant was not working to the best of her ability. Therefore, the claimant's separation was caused by her medically verifiable illness and does not constitute misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
The AT decision should be affirmed. As to the job separation, the claimant's employment was terminated after being issued a warning tied to the claimant's poor performance. The AT findings of fact established that the claimant had previously performed to the employer's standards. However, the claimant's performance later suffered significantly with decreasing accuracy and untimely case handling. Accordingly, the claimant mismanaged her position of employment. Therefore, we should affirm the AT decision, misconduct, reimbursing employer not billed.
The claimant submitted sufficient medical documentation and FMLA paperwork to show her decrease in work output was due to her various medical illnesses. Thus, she did not engage in misconduct. Reverse the AT, no misconduct, bill the reimbursing employer.
Short form dissent.
Yes, sir. Now, that was the last case pulled for additional discussion on docket 40B, turning to 41B.
Case number 3653146, Chairman Sparsa.
The AT decision should be affirmed. I do not contest the good cause issue as to the job separation. The claimant was discharged for conducting personal business using her company email address. While the claimant asserts that her usage of her company email address was accidental, ensuring that a non-prohibited email address is provided on a job application is not outside of one's power to control. Since the claimant admitting to using her company email address for personal use, which is essentially admission to engaging in activity that was prohibited by the employer, she mismanaged her position of employment. We should therefore affirm the AT decision. The claimant had good cause for a non-appearance, valid claim, misconduct, no chargeback.
The decision should be modified. I agree that the claimant had good cause for missing AT1 and filed a valid claim. However, regarding the job separation, the claimant made an honest mistake by inadvertently entering her company email address instead of her personal email address into a job search website. The claimant did not do this on company time, and it caused no harm to the employer's business. Additionally, the employer did not establish that this violated any specific policy, and the claimant had no prior warnings. Therefore, the employer did not meet its burden of proving or showing that the complainant's discharge was for misconduct connected with the work. Modify the AT. Claimant had good cause for AT1. Valid claim, no misconduct, chargeback.
The claimant mismanaged her position when she negligently used company property to apply to other jobs against the employer's business interest. Therefore, affirm the AT, valid claim, good cause, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3697183, Commissioner Trevino.
While the complainant filed his appeal to the commission after the deadline, this case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there is no separation from employment, and the continued claim should be voided. Deem the complainant's CA appeal timely, set aside the AT decision, void the continued claim.
The claimant's appeal should be dismissed as late because it filed beyond the applicable deadline to be considered timely. Accordingly, we should dismiss the claimant's commission of appeal as late, voluntary leaving, overpayment.
The available evidence on the voluntary leaving issue suggests that the claimant was sporadically working as a gig worker while looking for other work. Because appeal time limits do not apply to a determination that is found to have been void from inception, we should deem the commission appeal timely. The case should also be resubmitted to verify the underlying merits.
I'll agree with Commissioner Conant, ma'am.
Thank you. We will resubmit the case.
Case number 3701244, Commissioner Trevino.
The AT decision is not supportable. The claimant worked for a temporary help firm on assignment with the client company. The claimant resigned from her assignment due to inadequate training by the client company and reported to the employer for reassignment the same day that her assignment ended. Yet she was not offered additional work. Though the employer response stated that the claimant did not maintain contact with the employer did not appear at the hearing to provide any testimony. Section 207.045H of the Act provides that an employee of a temporary help firm who does not report for reassignment as instructed will be considered to have quit without good cause connected with the work. Since the complainant reported for reassignment and was not offered additional work, the claimant was laid off due to lack of work. Reverse the AT, no misconduct, no overpayment.
We should affirm the AT decision. The claimant voluntarily resigned. Claimant testified having a frustration and stressful time adjusting to her role at the client company. Following this, she reached out to her employer, temporary help firm. However, she failed to give the employer an adequate opportunity to address her concerns, and the claimant submitted her 2 weeks' notice. Additionally, the claimant did not establish that her working conditions were intolerable. Thus, the claimant quit without good cause connected with work. Therefore, AT decision should be affirmed, voluntary leaving, overpayment.
Because the claimant initiated the separation by quitting her assignment early and did not show the conditions were intolerable, the claimant voluntarily quit without good cause. Affirm the AT, voluntary leaving, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3731381, Chairman Sparsa.
The AT decision should be modified. The employer witness provided testimony that indicates she did not arrive at the office from being out of the country until after the scheduled time for the appeal hearing. The witness also added that no one else could have attended the hearing for the employer. Because the employer's representative had not arrived at the office from being out of the country until after the time of the hearing, the employer has established good cause for its non-appearance. We should therefore modify the AT decision. The employer had good cause for its non-appearance and resubmit.
The decision is correct. Regarding the good cause issue, the hearing notice for the AT1 hearing was mailed to the employer's correct address of record. The employer contends that they were unaware of the hearing until after it had already occurred because its primary representative had been traveling and did not receive the hearing notice until after the hearing was already finished on the day that she returned. Since the employer failed to establish that they missed the hearing for reasons beyond their own control, they failed to establish good cause for missing AT1. Regarding the job separation, the employer's protest alleged that the claimant had excessive absences and that his work was deficient. However, the employer's allegations were vague and not supported by any direct evidence of the claimant's actions, and the claimant denied any wrongdoing. Therefore, the employer failed to meet its burden in establishing misconduct. Affirmed the AT, employer did not establish good cause for AT1, no misconduct.
There is conflicting information in TWC records regarding what date the employer informed TWC she would be available for a hearing. Moreover, the employer diligently attempted to call into the hearing and filed a timely petition to reopen. Therefore, modify the AT, good cause, resubmit.
We will resubmit the case.
Case number 3734818, Chairman Sparsa.
The AT decision should be affirmed. Concerning the job separation, the employer terminated the claimant, a bank teller, after she failed to process a ticket of cash and left mutilated cash unattended at her station. The claimant was aware of the employer's cash handling procedures and admitted to leaving the mutilated cash unattended on her counter. As such, the claimant's actions violated a reasonable employer policy designed to protect employer assets, which constituted misconduct connected with work. Therefore, we should affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. The evidence established that the claimant did not intentionally violate the employer's cash handling policy, as she only left that envelope with the mutilated cash unsecured for a very brief period in order to find the proper paperwork for a monetary transaction her coworker requested, so that her own register would be properly balanced at the end of her shift. Also, she admittedly remedied the situation, and there was no financial loss to the employer. Therefore, under the circumstances, the claimant's actions should not be considered misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Since the claimant violated a reasonable company policy and acted carelessly when she left cash out unattended, the claimant was terminated for misconduct. Affirm the AT, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3735485, Commissioner Trevino.
The decision is correct and should be affirmed. The employer discharged the claimant for violating its attendance policy. The employer alleged that the claimant was tardy by 4 minutes on 2/29 of 24 and 1 minute late on 3/1 of 24. The claimant provided sworn firsthand testimony denying that she was late on either day. The employer's secondhand hearsay testimony is insufficient to overcome the claimant's sworn testimony denying the employer's allegations against her. Therefore, the employer failed to establish that the claimant's actions were misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The AT decision should be reversed. The claimant was terminated for violating the employer's attendance policy. Furthermore, the claimant received a performance improvement plan which alerted her that further attendance issued could lead to termination of employment. Despite this, the claimant continued a pattern of tardiness, including being tardy on the date of the final incident. As such, the claimant mismanaged her position of employment, and her actions constituted misconduct connected with work. Therefore, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The claimant engaged in misconduct when she failed to be ready for work at the employer's scheduled start time, despite receiving multiple warnings and being placed on 2 performance improvement plans. Therefore, modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3743989, Commissioner Trevino.
The decision is not supportable. The employer and the claimant agreed that the claimant was paid $1,669.14 in June of 2023 and $12,025.21 in the third quarter of 2023. The claimant worked full-time hours on a regular schedule and was paid by the hour on a weekly basis. The complainant's work had to be performed on the employee's premises, and the main equipment that he used in the performance of this work was provided by the employer. The claimant was also provided a list or job list to complete, and the employer required him to adhere to certain methods of doing the work to ensure proper safety practices were followed. Therefore, the employer asserted such direction and control over the complainant's work that his work was in employment, and the claimant should receive the requested wage credits based on the income received from the employer. Reverse CAT, claimant awarded wage credits in the amount of $1,669.14 for the second quarter of 2023 and $12,025.21 for the third quarter of 2023.
The AT decision should be affirmed. The preponderance of credible evidence in this case established that the services the claimant performed were not in employment. Accordingly, we should affirm the AT decision, claimant not entitled to wage credits from the named employer.
As the named company did not exercise sufficient control over the claimant should not be awarded wage credits for his work with the named company. Affirm the AT, no additional wage credits.
Short form dissent, ma'am.
Yes, sir.
Case number 3755977, Chairman Sparsa.
We should rehear this case to develop the record as to the final incident. The claimant was discharged for not abiding by verbal agreement. Fact-finding statements indicate that the final incident occurred when the claimant was fired for having a disagreement with the employer. However, the testimony from the employer and the employer's appeal show the claimant was rehired. Testimony from the parties on the issues does not appear to have dates, which results in an unclear picture of when the evidence in this case occurred. As such, more testimony from the parties should be obtained for clarification. Thus, we should grant a rehearing to further develop the record regarding the final incident that led to the claimant's discharge and for testimony on the dates associated therewith.
The decision is correct. The employer discharged the claimant for failing to properly perform her job duties. The complainant was then rehired shortly thereafter, but was informed that she would not be paid for the 2 weeks that she had not worked before returning to her job. The claimant provided firsthand testimony that when she asked for further clarification from her employer about the discrepancy in pay, she was then discharged. While the employer alleged that the claimant was insubordinate while obtaining further information about her pay, the employer failed to provide any direct evidence to show that the claimant's actions were improper. Therefore, the employer failed to meet its burden of establishing that the claimant's actions were misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Because this is a discharge, the employer carries the burden of proving misconduct. However, the employer failed to provide any additional documentary or testimony evidence to overcome the claimant's consistent firsthand denial of insubordination. Additionally, the employer failed to prove that the claimant's request for additional pay were unreasonable. Therefore, affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. And that was the last case pulled for additional discussion on docket 41B, turning now to 42B.
Case number 3670800, Commissioner Trevino.
The decision is not supportable. Although the employer discharged the claimant for performance issues, the evidence clearly showed that the claimant had performed her work adequately for several years until her workload greatly increased over the last year due to staffing problems. Additionally, the claimant consistently sought guidance from management about what work to prioritize. The claimant's entire team was having issues meeting deadlines, and their supervisors struggled to give proper direction on addressing the increased workload and staffing shortages. Therefore, since the claimant was working to the best of her ability, but was unable to meet the performance standards due to circumstances beyond her control. She was discharged for reasons other than misconduct connected with the work. Reverse CAT, no misconduct, bill reimbursing employer, void adequate response.
The AT decision should be modified. Regarding the job separation, the claimant, a behavior specialist, was discharged after failing to meet deadlines and not performing satisfactorily. The employer issued a written warning to the claimant relating to her untimeliness on submission of support plans and behavioral assessments, both critical elements of her role. Regardless, the claimant continued to turn in items late and had outstanding items at the time of her discharge. The claimant contends she was not given a counseling session on how to improve her performance, though this does not overcome the fact that she failed to submit assessments on time, and the untimeliness impacted the agency's obligations to an outside monitoring agency and the safety of others. Accordingly, the claimant's action constituted work-connected misconduct, and we should modify the AT decision, misconduct, reimbursing employer not billed, sever adequate employer response.
The claimant committed work-connected misconduct when her continued poor performance put patients at risk following a final warning and despite coaching from the employer. Modify the AT, misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent, ma'am.
Yes, sir.
Case number 3701014, Commissioner Trevino.
While the claimant filed her appeal to the AT after the deadline, this case involves a continued claim related to the claimant's working as a marketplace contractor in self-employment. As such, there is no separation from employment, and the continued claim should be voided. Timely claimant appeal, set aside the AT decision, void the continued claim.
We should affirm the AT decision. Although the claim determination was timely received by the claimant, should not open the determination in a timely fashion and failed to file a timely appeal. Since there are no good cause exceptions to the timeliness rules, we should find the claimant's appeal late and leave the underlying determination in full force and effect. Untimely claimant appeal, voluntary leaving, overpayment.
The available evidence on the voluntary leaving issue suggests that the claimant was sporadically working as a gig worker while looking for other work. Because appeal time limits do not apply to a determination that is found to have been void from inception, we should deem the appeal timely. The case should also be resubmitted to verify the underlying merits, modify the AT, timely appeal, resubmit.
Ma'am, I'll agree with Commissioner Conant.
Thank you, sir. We will resubmit this case.
Case number 3705498, Commissioner Trevino.
The decision is not supportable. The claimant worked for the employer on a long-term assignment for a year and a half. When the complainant learned the assignment was ending, she was not given any instructions to report to the employer for further assignments, and no further work was offered to her. While the employer had a reporting policy, the complainant only electronically signed this several weeks before her start date, and she was never given a copy of the policy. Additionally, the claimant reached out to her on-site supervisor to inquire about further work, but she did not receive a response and was not reminded of the reporting policy. Therefore, the evidence shows that the claimant's separation occurred when her long-term assignment ended, and she was neither given any instructions on how to request other assignment, nor offered another assignment. Reverse CAT, no misconduct, chargeback, void adequate response.
We should modify the AT decision. The claimant admitted she did not read the policies provided to her at the time of her hire. Since she did not comply with the employer's reporting requirements, she is considered to have quit without good cause connected with the work. As such, we should modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue.
The claimant has not met her burden in proving she left with good cause, as she provided inconsistent testimony regarding whether she contacted the employer for reassignment. Meanwhile, the employer provided sworn testimony that it had no record of her reporting for reassignment. Therefore, modify the AT, voluntary leaving, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3720443, Chairman Sparsa.
The AT decision should be affirmed. I don't contest the good cause issue. As to the job separation, the claimant was discharged following his arrest outside the employer's place of business. Charges against the claimant were made public and broadcast on the news. In addition, the claimant was told that the police were calling in to the corporate office to inquire about the arrest. Excuse me, the people were calling in to the corporate office to inquire about the arrest. Moreover, the other employers shared the incident on an internal website. Due to the employer's interest in maintaining its reputation, the claimant being arrested outside the place of business is misconduct connected with work. As such, we should affirm the AT decision. The claimant had good cause for his non-appearance, misconduct, no chargeback.
The decision should be modified. I agree that the claimant established good cause for AT1. However, regarding the job separation, the employer discharged the claimant after learning he had been arrested. The complainant pled not guilty to the charges, and no evidence has been submitted showing that the claimant was convicted of any crime. Therefore, the employer did not establish that the claimant was discharged for misconduct connected with the work. Modify the AT. Claimant had good cause for AT1, no misconduct, chargeback.
The weight of the evidence suggests that the claimant's arrest caused harm to the employer's interests and reputation. As such, the claimant was terminated for misconduct. Affirm the AT, good cause, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3723917, Chairman Sparsa.
The AT decision should be affirmed. Regarding good cause, the claimant was not prevented from attending the AT hearing due to circumstances beyond his control. As such, he did not have good cause for his non-appearance. As to the job separation, the available record supports disqualification from benefits. The employer provided a fact-finding statement from a person who stated that the claimant admitted to them that he was asleep on the job when an individual got mugged. Since the claimant was sleeping on the job when he was expected to be working, his actions constituted misconduct connected with the work. We should therefore affirm the AT decision. The claimant did not have good cause for his non-appearance, misconduct, no chargeback.
The AT decision should be modified. I don't contest that the claimant failed to establish good cause for not appearing at AT1. However, regarding the job separation, although the employer discharged the claimant because they alleged that he was sleeping on the job, the employer only provided a disciplinary report stating that this was reported by 2 employees without any additional evidence. The claimant credibly and consistently denied the allegations. Therefore, the employer has failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Modify the AT. Claimant failed to establish good cause for AT1, no misconduct, chargeback.
We should find good cause to avoid penalizing the employer by having their testimony withheld due to the claimant's non-appearance. All the available AT2 testimony should be summarized. Therefore, modify the AT, good cause, resubmit.
All right, we have majority vote that there was no good cause, but no agreement on the merits between the chairman and Commissioner Trevino.
I'll agree with Chairman Connett.
Majority vote is good cause and resubmit. We will resubmit.
Case number 3725537, Chairman Sparsa.
The AT decision should be modified. The claimant was terminated after she experienced issues with her internet connection, which led to the claimant engaging in a call avoidance. Claimant was advised by the employer to come into the employer's premises, but an employer witness testified that the claimant was unable to do so due to medical issues. Since the claimant was prevented from adhering to the employer's instructions due to medical issues, claimant should be qualified for benefits and the employer's account should be protected from charge. We should therefore modify the AT decision. No misconduct, no chargeback, MVI, void, adequate employer response.
The decision is not supportable. The claimant was discharged for alleged call avoidance. The claimant provided sworn firsthand testimony that she was experiencing internet issues, which affected both her phone and computer, and denied under oath that she engaged in any deliberate act of call avoidance. She also testified that she made good faith effort to notify her employer about the technical issues by walking over to a neighbor's house to request the use of their phone and going to the employer's location the next day. Since these technical issues were the primary cause of the call avoidance, the employer has not met its burden of showing that the claimant committed any intentional actions of call avoidance, and the employer did not establish that the claimant's discharge was for misconduct connected with the work. Reverse CAT, no misconduct, chargeback, void adequate response.
The claimant mismanaged her position of employment by not reporting to work in person the day she experienced technical difficulties like the employer asked her to do. Modify the AT, misconduct, no chargeback, sever adequate employer response.
I'll agree with Commissioner Khanna.
Thank you, sir. The majority vote is misconduct, no chargeback, sever, adequate employer response.
Short form dissent, ma'am.
Thank you, sir.
Case number 3739146, Commissioner Trevino.
The decision is not supportable. The claimant worked a long-term assignment for a year and a half, for over a year and a half, and he was then notified that the PEO that he was employed by had lost the contract at the client company where he worked and that he was going to be laid off. Although the PEO sent the claimant an email notice of the layoff, this email was sent prior to the layoff and was sent to an outdated email address for the complainant. Therefore, the PEO did not fulfill the requirements under 207.045I by giving the complainant a written instruction to contact the PEO for reassignment at the time of his assignment ended. Additionally, the claimant kept in frequent contact with the client company about returning to work and was neither offered any further work nor reminded of the need to contact the PEO. Therefore, the complainant's separation was due to lack of work and not for any disqualifying reasons. Reverse CAT, no misconduct.
We should affirm the AT decision. The employer at PEO required its employees to report for reassignment at the end of a job term. Although the claimant was aware of the employer's reporting instructions, he did not follow the requirements for reporting and did not report for further work. Since the claimant was aware of the employer's instructions, his failure to report for further assignments constituted a voluntary quit without good cause connected with the work. As such, we should affirm the AT decision, voluntary leaving.
The claimant admitted that he received the written instructions on how to report for reassignment, but he failed to read them. As he has not shown he had good cause for his failure to report for reassignment, we should affirm the AT decision, voluntary leaving.
Short form dissent, ma'am.
Yes, sir.
Case number 3740739, Commissioner Trevino.
The decision is not supportable. The claimant was discharged for attendance. When the claimant received news that she had an urgent issue involving her minor child that needed immediate attention, she was granted permission by her supervisor to take an early extended lunch and return to work later that afternoon. She was not given a specific time by which she needed to return. The claimant relied on her supervisor's approval to take an extended lunch without work to address the issue with her son, and then return later that day. The employer then assessed the claimant points for the extended lunch and discharged her for violating the attendance policy. Since the complainant was given approval for the extended lunch and was not told that she would be assessed points if she failed to return by a certain time, the claimant was discharged for reasons other than misconduct connected with the work. Reverse CAT, no misconduct, chargeback.
We should affirm the AT decision. The claimant was on a final warning for attendance infractions. The claimant was thereafter terminated when she continued to accrue attendance points in violation of the employer's policy. While the claimant alleged she had more available points, this is not supported by the record. The claimant's final warning clearly stated that the accrual of any additional attendance occurrences will result in termination. The claimant continued to accrue additional attendance infractions, which resulted in her discharge. As such, her actions constituted mismanagement of her position of employment, which amounted to misconduct connected with the work. Affirm the AT decision, misconduct, no chargeback.
The claimant was terminated for misconduct because she was late for work after receiving a final warning for her attendance. Affirm the AT, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3746603, Chairman Sparsa.
The employer's CA appeal should be deemed timely. The employer provided testimony that it did not receive the AT decision until the day of the appeal deadline. This essentially cut the employer's appeal window to 1 day. Since the employer was only afforded a fraction of the customary 14-day appeal window, its appeal should be deemed timely. Accordingly, we should find the employer's CA appeal timely and resubmit the case.
The employer's appeal to the commission should be dismissed as late. The AT decision was mailed to the employer's correct address, which was the employer's third-party representative. The employer's appeal acknowledged that the decision was received at that address within the appeal period, yet the employer did not file a timely appeal. The commission does not have jurisdiction due to the employer's late appeal. Dismiss the employer's CA appeal as late and leave the AT decision in full force and effect. No misconduct, chargeback.
The employer's appeal should be deemed timely because their appeal provides that they did not receive the decision until the day of the deadline. Modify the AT, deem commission appeal timely, resubmit.
We will resubmit the case.
Case number 3749397, Commissioner Trevino.
The AT decision is not supportable. The claimant provided credible and consistent testimony that he did not receive the determination in a timely manner. The determination was mailed to his address of record, which is an office that receives the claimant's mail. The claimant testified that the determination was not received until after the appeal deadline because the office informs him via email the same day that the mail is received, and that he was not informed that the determination was received until after the deadline. The claimant's credible and consistent firsthand testimony is sufficient to rebut the presumption of receipt. Therefore, the claimant's appeal should be deemed timely and the case resubmitted for merits testimony. Reverse the AT, timely claimant appeal, resubmit.
We should affirm the AT decision. Concerning timeliness, although the initial determination was sent to the claimant's correct address of record, he failed to file a timely appeal because he did not proactively check his mail. Since the claimant did not file a timely appeal due to circumstances which were directly within his power to control, we should dismiss the claimant's appeal as late and leave the underlying determination in full force and effect. Affirm the AT decision, untimely claimant appeal, voluntary leaving, void the chargeback ruling.
It was ultimately the claimant's responsibility to consistently check his mail for TWC correspondence. As such, we should not deem the claimant's appeal timely. Therefore, affirm the AT, untimely appeal, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3942031, Chairman Sparsa.
We should affirm the AT decision. The claimant voluntarily left his position. The claimant pointed to the promotion of the employer's loyalty cards as evidence of misrepresentations of the job. However, the job description mentions promoting the cards as a task. Additionally, the claimant deemed the working environment to be toxic. However, he failed to show the conditions were so intolerable that he had no other choice but to quit. Claimant's dissatisfaction with his working conditions in this case did not constitute good cause for quitting. Therefore, the claimant voluntarily quit without good cause connected with work. The AT decision should be affirmed as voluntary leaving, void chargeback.
The decision is not fully supportable. The claimant resigned from his job due to intolerable working conditions and a hostile work environment. The claimant provided credible firsthand testimony that he reported to the store manager and the human resource representative that he was being encouraged to use tactics such as lying to customers to sell certain items, that the working environment was hostile due to the use of profanity by other employees. The employer failed to sufficiently address or resolve the claimant's concerns and instead joked about the matter. Therefore, the claimant had good cause connected with the work for quitting his job. Modify the AT, no voluntary leaving, void chargeback.
The claimant has not shown that the working conditions were intolerable or that he gave the employer adequate opportunity to address his concerns. Moreover, the claimant was offered additional work in a different position and declined. Affirm the AT, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir. That was the last case pulled for additional discussion on docket 42B. This ends agenda item 9.
Fantastic. Thank you. We will now turn to agenda item 10 for consideration of UI cases on docket 44. I understand that there are UI cases pulled for additional discussion.
Yes, sir.
Very good. Please proceed.
Thank you. One moment, please.
Case number 3568497, Commissioner Trevino.
The decision is not supportable. First, I do agree that the claimant filed a timely CA appeal. Regarding the complainant's petition to reopen for AT2, the claimant testified that she received the decision within the appeal time period. The claimant contacted the commission representative to ask questions about her case on the same day as the deadline to appeal that decision. Since the claimant called the telecenter during the appeal deadline time period and asked questions about her case and was not informed about her appeal rights and that she needed to file an appeal that same day, her petition to reopen should be deemed timely due to misinformation from the TWC representative, and the case should be resubmitted for a summary of merits. Deem the complainant's CA appeal timely, modify the AT, timely petition to reopen, claimant establish good cause for AT1, timely claimant appeal, resubmit.
I don't contest the claimant's CA appeal was timely concerning the claimant's Rule 16 petition to reopen. Despite timely receiving the AT decision, the claimant delayed filing the appeal because she had questions about her case. The claimant contacted the telecenter and the hearing officer on the last day for a timely appeal, but the record does not show that the claimant was misinformed in any way about her claim. Since there are no good cause exceptions to the timeliness rules, we should deem the claimant's CA appeal timely and affirm the AT decision. Untimely Rule 16 petition to reopen, timely claimant appeal. The claimant is not entitled to wage credits from the named employer.
We should find that the claimant's commission appeal timely because she consistently testified that she did not receive the AT2 decision. However, the claimant did not file a timely petition to reopen because she filed late despite receiving the AT1 decision and knowing of the appeal deadline. Therefore, modify the AT, deem commission appeal timely, late petition to reopen, timely appeal, no additional wage credits.
Short form dissent, ma'am.
Yes, sir.
Case number 3672464, Chairman Sparsa.
The AT decision should be modified. First, I don't contest the good cause issue. As to the job separation, the claimant abandoned her position of employment by failing to return to work after a lunch break. In addition, the claimant informed the office manager she would be bringing her shirt and keys. This behavior signaled to the employer that the claimant was leaving her position of work. This behavior constitutes a voluntary leaving. Therefore, we should modify the AT decision. The claimant established good cause for missing the AT hearing, correct LEU, voluntary leaving, void the chargeback ruling.
The decision should be modified. I agree that the claimant had good cause for missing AT1 due to technical problems outside of her control, and that the employer named on the claim needed to be corrected. As to the job separation, the weight of the evidence established that after the complainant expressed some doubts about staying on the job after learning that a new owner was looking to replace her, the complainant's manager advised her to go home for the rest of the day and that her manager would contact her later about returning to work. However, the manager did not reach back out to the complainant. When the complainant then messaged the manager about returning to work, the manager told the complainant that she should not return because the owner had decided that she had quit. Since the claimant had not made an equivocal expression of her intent to resign from her position, the employer initiated the separation by telling the claimant that she had quit and could not return to the job. Therefore, it was proper for the AT to conclude that the claimant's separation was involuntary and for reasons other than misconduct connected with the work. However, since the employer is not a base period employer, the chargeback ruling should be voided. Modify the AT. Claimant had good cause for AT1. Corrected last employer. No misconduct. Void chargeback.
The employer did not give the claimant an unequivocal expression of an intent to terminate her. Accordingly, the claimant quit without good cause when she failed to clarify her job status with the employer, did not return to work after the final incident, and failed to prove that the work conditions were intolerable. Modify the AT, good cause, AT2 correctly named the LEU, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3677407, Commissioner Trevino.
The decision is not supportable. The employer discharged the claimant after he failed to pass the bar exam. The complainant worked as a clerk for the employer's law firm. The claimant was aware that he would transition to an attorney position once he passed the bar. However, the firsthand testimony provided by the complainant established that he was not informed that he would be fired from a clerk position if he was unable to pass the bar exam. Failing to pass a difficult test, such as the bar exam, should not be considered misconduct without showing some other appropriate action on the complainant's part. The employer admitted that there was no other reason for the complainant's separation. Therefore, the complainant's discharge were for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
The AT decision should be modified. The claimant anticipated his research and briefing clerk position to bridge into the briefing attorney position. However, this change in his position was dependent on passing the bar exam of Texas. After attempting the exam twice, the claimant had yet to receive the credentials necessary for the briefing attorney position. As such, the actions were a mismanagement of his position of employment and constituted misconduct connected with the work. Therefore, we should modify the AT decision, misconduct, no chargeback, sever adequate employer response.
The employer's testimony that the claimant's clerk role was a temporary position should be given greater weight. As such, the claimant's failure to pass the bar exam, despite being put on notice that he had to attempt to pass, constitutes misconduct. Modify the AT, misconduct, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3701868, Chairman Sparsa.
The AT decision should be affirmed. Final incident resulting in the claimant's discharge was a physical altercation between the claimant and her manager. There's a zero tolerance policy on fighting at the workplace, so involvement in this altercation was grounds for discharge. As such, the claimant's behavior constituted misconduct connected with the work. We should affirm the AT decision, misconduct, void the reimbursing ruling. In the alternative, the Commission should rehear this case. Given the severity of the situation, the employer should provide witness testimony or relevant evidence. As the employer testifies, there are witnesses who saw the claimant provoke the manager. We should rehear this case to question the parties and to admit the employer's additional evidence regarding the job separation. Rehearing the alternative.
The decision is not fully supportable and should be modified. The employer discharged the claimant due to her involvement in a physical altercation with her manager, which violated the employer's zero tolerance policy against fighting. The claimant provided sworn firsthand testimony that her manager instigated the physical altercation by pushing her and then pulling her hair. The complainant testified that she was not the aggressor and only made physical contact so that she could defend herself. The employer was unable to present any firsthand evidence to support its contention that the claimant was the aggressor, and only the complainant was discharged for the altercation, which shows that the employer was not equally enforcing its zero tolerance policy. Therefore, the employer did not meet its burden of proof in establishing that the claimant was discharged for misconduct connected with the work. Modify the AT, no misconduct, void reimbursement rule.
It's important for there to be sufficient evidence of who started the fight and to avoid infringing on an individual's right to self-defense. Thus, the case should be reheard so the employer can present either a witness or a witness statement to better support their allegation that the claimant started the physical fight. Rehear.
We will rehear the case.
Case number 3728639, Commissioner Trevino.
The AT decision should be modified. I do not contest the timeliness or overpayment issues. However, the evidence in this case does not establish that the claimant acted to willfully misrepresent her earnings sufficient for the fraud and forfeiture provisions of Section 214.003 to apply. The claimant worked for the employer irregularly as a bartender and was paid both an hourly wage of $10 an hour and sometimes received tips. According to both the complainant and the employer's testimony, the complainant had no way of knowing what her tips for any shift were until she received her paycheck. The complainant reported her hourly wage when filing her payment request and attempted to contact the commission for assistance on how to properly report her earnings. Therefore, the claimant did not willfully fail to disclose or misrepresent her earnings to the commission. Modify the AT, claimant filed a late appeal to the 2/5/24 determination. Earnings adjustment overpayment of $1,562. No fraud, recalculate overpayment.
The AT decision is supportable. Concerning timeliness, the claimant conceded that she filed a late appeal to the February 5th determination. The claimant was not prevented from filing a timely appeal due to circumstances beyond her control, so the AT dismissal of the appeal should be affirmed. The AT decision as to the fraud issue is also supportable. Claimant willfully did not report her earnings from tips for multiple benefit weeks. Moreover, the claimant provided inconsistent and contradictory testimony when questioned on the issue. The instructions to the claimants are very clear that all work and earnings must be reported for each week claimed. Since the claimant did not report all available earnings, we should find that the claimant committed claim fraud. Affirm the AT decision, untimely claimant appeal, earnings adjustment overpayment. Claimant committed claim fraud covering the period from October 1 to 2023 through September 28th of 2024. Overpayment.
Because the claimant willfully failed to report her tips, it's reasonable to argue that she engaged in fraud under Section 214.003 of the Act. Therefore, affirm the AT, late appeal, leave the underlying determinations in full force and effect.
And you are voting to affirm the fraud and the overpayment related to the fraud, sir?
That's correct.
Thank you.
A short form dissent, ma'am.
Yes, sir.
Case number 3728655, Commissioner Trevino.
The AT decision should be modified. As in the prior case, I do not contest that the claimant received benefits to which she was not entitled. However, the evidence does not establish that the claimant acted to willfully misrepresent her earnings sufficient to the fraud or forfeiture provisions of Section 214.003 to apply. The complainant worked for the employer for one day as a bartender, received no tips, and reported her earnings to this particular employer. Modify the AT, no fraud, recalculate overpayment.
The AT decision. Excuse me. Okay. The AT decision is supportable. The claimant failed to report earnings for several weeks and significantly underreported her earnings for several other weeks. The claimant received basic information from TWC regarding claim filing requirements, including the need to report all work and earnings while filing benefit claims. When filing her claim, she willfully failed to report all of her earnings during the claim filing period and thereby claimed benefits to which she was not entitled. Accordingly, we should affirm the AT decision. The claimant committed claim fraud covering the period from October 1 of 2023 through September 28 of 2024 overpayment.
Because the claimant willfully failed to report tips she received from other employers while she was receiving benefits, she engaged in fraud under Section 214.003 of the Act. Affirm the AT, fraud, forfeiture, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3728657, Commissioner Trevino.
The AT decision should be modified. As in the two prior companion cases, I do not contest that the claimant received benefits to which she was not entitled. However, the evidence does not establish that the claimant acted to willfully misrepresent her earnings sufficient to the fraud and forfeiture provisions of Section 214.003 to apply. The complainant began working for this employer as a bartender while she was filing for benefits and attempted to report her earnings correctly, but did not have access to her pay stubs and was confused by the process. This does not establish willful action. Modify the AT, no fraud, recalculate overpayment.
The AT decision is supportable. The claimant failed to report earnings for several weeks and significantly underreported her earnings for several other weeks. The claimant received basic information from TWC regarding claim filing requirements, including the need to report all work and earnings filing benefits claims. When filing her claim, she willfully failed to report all of her earnings during the claim filing period and thereby claimed benefits to which she was not entitled. Accordingly, we should affirm the AT decision. The claimant committed claim fraud covering the period of October 1, 2023 through September 28th of 2024, overpayment.
The claimant willfully failed to report her tips, which constitutes fraud under the Act. Therefore, affirm the AT, fraud, forfeiture, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3731431, Chairman Sparsa.
We should modify the AT decision. First, I agree that the employer established good cause for missing the AT hearing. Concerning the job separation, the claimant was repeatedly warned about her disrespectful behavior. Despite this, the claimant's unprofessional behavior persisted on her final day. In addition to her lack of professionalism toward her coworkers, the claimant also used demeaning language to address her supervisor in reference to an email. When questioned by the hearing officer, the claimant did not deny her conduct. Since the claimant was aware of the employer's professionalism rules, her poor and disrespectful workplace actions constituted misconduct connected with the work. As such, we should modify the AT decision. The employer established good cause for missing the AT hearing, misconduct, no chargeback, adequate employer response.
The AT2 decision is correct. I do not contest that the employer established good cause for its failure to appear at AT1. Regarding the job separation, the claimant was discharged for making inappropriate comments about another employee. The employer alleged that the claimant's comments created a hostile work environment. While the complainant did admit to making the comment about the owner regarding an email that was sent to her, she did not specifically address the person individually and was merely venting to her coworkers. Since the employer was unable to provide any direct evidence about the claimant's conduct, and its witnesses with firsthand knowledge were unable to corroborate what specific comments the claimant made, the employer has failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, employer established good cause for AT1, no misconduct, chargeback.
The employer presented ample firsthand and secondhand evidence that the claimant created a hostile work environment through her repeated rude and demeaning comments. Thus, we should find that the claimant was discharged for work-connected misconduct because this behavior continued despite warnings. Modify the AT, good cause, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3976174, Commissioner Trevino.
This case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there was no separation from employment, and the claimant's continued claim should be voided. Set aside the AT decision, void the continued claim.
The AT decision should be affirmed. In this job, the claimant testified she was responsible for providing her own transportation to work. She resigned from her position when she lost her only reliable means of transportation. Since the claimant was responsible for providing her own transportation to work and she quit because of the lack of transportation, the claimant quit this role voluntarily. As such, we should affirm the AT decision, voluntary leaving.
The claimant's work as a gig driver was not in employment, and thus there was no separation. The claimant's honest reporting of sporadic gig work should not result in the claimant's disqualification. Set aside the AT, void the continued claim.
Short form dissent.
Yes, sir. And that is the last case pulled for additional discussion on docket 44. You should have received the UI short form dissent list for docket 44.
I move that we accept staff recommendations on the remaining UI cases on docket 44.
And I second the motion except for those cases which I am dissenting, as reflected on the UI short form dissent list for docket 44.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in UI short form dissent list for docket 44.
The motion passes with the exceptions noted. That concludes our work on agenda items 3 through 10. Chairman Esparza, I hand the meeting back over to you.
Thank you, Commissioner Conitt. Thank you all. Sherry, thank you for keeping us organized. We're getting closer to the end there. So thank you all. We're going to pause for the shuffle.
Thank you, gentlemen, very much.
Hey, thanks, everybody. We're back. We're going to take up item 11, possible action regarding local workforce development board performance.
Good morning, Chairman, Commissioners, Mr. Townsend. For the record, Jennifer Kohlhauer, Information, Innovation, and Insight Division. Today for your consideration is the discussion paper for board contract year 2026, career and training choices and reemployment and employer engagement measure performance targets and expectations for local workforce development boards. These are also known as the non-WIOA and non-child care measures. For the following measures, the recommendation is to maintain the same methodology and targets used in board contract year 25 for the upcoming board contract year 26. And those four that would stay the same are active job seeker new employment connection rate, maintaining employment connection rate, successful Texas talent assistance rate, and choices full engagement rate. There are three measures for which staff recommends changes to targets or methodology for board contract year 2026 as set out in the discussion paper. And those three are credential rate, all career and training participants, number of employers receiving Texas talent assistance, and claimant reemployment within 10 weeks. And with that, staff recommends the approval of the targets and methodologies for board contract year 2026 as detailed in the discussion paper in your meeting materials. Happy to answer any questions you may have.
Thanks, Jennifer. Commissioners, any questions or comments?
None here.
No, thank you.
Thank you for the presentation and recommendations. Is there a motion?
Chairman, I move that we approve the local workforce development board performance targets and methodologies for board contract year 2026 as described in the discussion paper and recommended today by staff.
I second.
I also vote yes, motion passes. Thank you.
Thank you.
On to item 12, possible action regarding certifications and recertifications, rehabilitate programs.
Good morning, Commissioners. Mr. Townsend, Juan Garcia with the Voc Rehab Division. This morning, for your consideration, we have 2 CRPs that are applying for first-time certification and 3 CRPs that are applying for recertification. The 2 new CRPs are as follows: the Hale Foundation Corporation in Texas City and the Veterans Advocates Services and Training in Houston. The 3 CRPs that are applying for recertification are as follows: Goodwill Industries of San Antonio, On Our Own Services in Houston, and the EV Foundation in Corpus Christi. Staff recommends certifying 2 new CRPs and recertifying 3 existing CRPs for participating in the PPD program. So with that, I can answer any questions you might have.
Thank you. Any questions, Commissioners?
None here.
No, thank you.
Is there a motion?
Chairman, I move that we approve the certifications and recertifications of the following community rehabilitation programs for participation in the Purchasing from People with Disabilities program as recommended today by staff. The certification of Hill Foundation Corporation and Veterans Advocates Services and Training, and the recertification of Goodwill Industries of San Antonio, On Our Own Services Incorporated, and EB Foundation.
Second the motion.
I also vote yes, motion passes and carries.
Thank you.
Thank you, Juan. Item 13, public comment for proposed rule review, purchasing products. Mr. Reed?
All right, I think we've still got a couple more minutes here to say good morning. So good morning, Commissioner, Chairman Esparza, Commissioners Trevino and Connett, and Mr. Townsend. For the record, I'm Reed O'Brien with the Office of General Counsel. Texas Government Code Section 2001.039 requires state agencies to review their rules every 4 years and determine if the rules should be readopted, revised, or repealed, and whether the original reasons for adopting them continues to exist. This process also ensures that our rules are not obsolete. They remain aligned with current law and policy and continue to reflect the Commission's procedures. Chapter 806, Purchases of Products and Services from People with Disabilities, is due for its 4-year review. And before you today, for your consideration, is TWC's notice of intent to review those rules. Staff requests the Commission's approval to submit the notice for publication in the Texas Register for a 30-day public comment period. And once the comment period ends, staff will return to present our findings of the review and any recommendations. This concludes my presentation. I'm available for any questions.
Any comments or questions?
None here.
No, thank you.
All right, thank you.
Thank you, Reed. Is there a motion?
Chairman, I move that we approve the proposed rule review for 40 Texas Administrative Code, Chapter 806, Purchases of Products and Services from People with Disabilities, and the production or publication for public comment as recommended today by staff.
I second.
I also vote yes, motion passes. Thanks, Reed.
Thank you.
Next, item 14, possible action regarding approval of local workforce development board nominees.
Still, good morning. Good morning, Chairman, Commissioners, Mr. Townsend. For the record, Patricia Martinez, Workforce Development Division. Today for your consideration, we have workforce board nominations for Workforce Solutions Northeast Texas, West Central Texas, Southeast Texas. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Okay, I believe we have public comment, Les, for this item.
Yes, sir, we do. We have Samuel Garcia. Garcia, if you could unmute yourself and begin.
Can you hear me?
Yes, sir, we can.
After watching the last meeting on the 21st, staff recommended that all board nominees be approved as recommended. There was a laundry list of them. Then Commissioner Brent Conant, who was appointed less than a month before this meeting on September 26, said, "I'd be in favor of moving forward on all these board slate of nominees with the exception of West Central Texas. I have some questions I'd like to pose with staff about that particular group of nominees." That's what he called it, group of nominees. He then made the following motion. I would move that the proceeding that we postpone consideration of local workforce development board member nominees for West Central Texas, and that we approve nominees presented for Cameron, North Central, Heart of Texas, Golden Crescent, Middle Rio Grande, North Texas, Permian Basin, and South Plain. It was then seconded by Commissioner Trevino and made unanimous by Chairman Esparza. I was informed last Friday that my nomination was being questioned, and when I asked why, I was told by our local board staff that they did not know. They were not given a reason. I watched the video of the meeting the next day and also saw the posting for today's meeting and saw that my name had been removed from the list of nominees. As far as I know, I'm still a nominee and for another term as approved by our local Chamber of Commerce and approved by our local county chair, county judges. They have both signed off on my nomination. And the local staff does not have the authority to withdraw my nomination. I want to know if the commissioners asked about the entire slate of nominees of West Central, and also not once in this motion did he mention me. I was not mentioned. It was a group. Why am I the only nominee removed? I would ask if there's a discussion between any of these commissioners outside of public meeting that would have resulted in this change. I believe I deserve to know what questions Commissioner Connett had about me or the other two commissioners. I assume that's why I was removed. If it's my qualifications, because I will put my workforce employer experience, education experience, and community involvement up against any nominee from our board or any of the other 28 board. I was the 2018 National Association of Workforce Board Small Business Leadership Award winner. I was a finalist in the Texas Workforce Commission Small Employer of the Year. I was winner of the Abilene Chamber of Commerce Small Businessman of the Year. I'm a two-term West Central Texas Board Chair. I was the 2013 Small Business Administration Minority Small Business Champion. I'm a past two-term school board member. I have over 30 years of being in business and a countless number of community service roles. If you do approve the other 6, when will my nomination come up for consideration? Since our board is still in compliance, I believe you should vote for all of the board members as presented at once and not single me out. And I am here if you have any questions, because I want to know what is it about me that caused you to take it off. I have a reputation when it comes to workforce board and just by the awards that I've won on being a very, very diligent volunteer. And this is a volunteer position. I've heard you discuss these cases over the last couple of hours, and you're trying to use facts to determine the way you vote. But when it comes to voting on me as to continue another term on our local board, which I have a great relationship with our board, I don't have any facts. And so I would love to hear the facts as to why my name was removed and where the other board members looked at. What's the reasoning behind this? Thank you.
Mr. Garcia, I appreciate your experience and service to the board. Obviously, my consideration is West Central Texas is seeing some critical emerging technologies out there, and I feel that there's an opportunity and would like the opportunity to discuss with the recommending authorities there, be it the Chamber of Commerce or the county judge, the opportunities for those emerging industries to be recognized and to be to have their experience on the board, if that is if there's the opportunity to do so. And we appreciate your time and your service to the board, and appreciate your comments today. Thank you.
So you're saying, can I ask a question?
Is there a motion for be considered?
Chairman, I move that we approve the local workforce development board member nominees presented today for the following: Workforce Solutions Northeast Texas, West Central Texas, and Southeast Texas.
Second the motion.
I also vote yes. Motion passes on item 15. Possible action, Sunset Advisory Commission. Nothing for 15.
Nothing today.
Okay, nothing. Anything for 16? No for Michael Britt. Number 17.
No director's report.
No director's report. So that's item 18. Anything else for the week?
Nothing today.
Thanks, everybody. That'll conclude. Is there a motion?
Chairman, I move to adjourn.
I second the motion.
All motion is seconded and passes. Motion carries. We are adjourned.